The Dershow.
We have the right to know whether or not Fannie Willis selected as her special prosecutor a man with whom she's having not only a romantic relationship, but a financial relationship. It affects the case. It affects whether the case should have been brought at all in the first place, whether or not this was simply an attempt to convey funds from one lover to another. You can't claim privacy about issues of this kind. These are issues that go to the core of our system of justice. Here you have an elected official bound, and also a lawyer, bound by rules of ethics, both legal ethics and also state legislative ethics. One, because she's an elected office holder and a very high office holder. The district attorney is a very, very powerful position indeed in the legal system. The district attorney is more important than the judge in so many ways. The judge is on the receiving end. The judge can decide how cases should be resolved, but it's the prosecutor who brings the cases, who has the ultimate discretion to decide which cases to bring, what to charge, all of those things. It's a very, very high position. And then she appoints a special prosecutor. Why her office couldn't handle this, we'd have to hear. And why did she pick him? He doesn't have experience in RICO case, a complex case. I know I've litigated a lot of RICO cases, primarily on appeal, but I know the RICO laws very well. I testified as an expert witness on RICO laws in Russia some years ago. So I know what I'm talking about when it comes to RICO laws. And this guy, Nathan Wade, if you look at his resume and his background, he's not the guy who seems most qualified to serve as a special prosecutor in lieu of the ordinary prosecutors in the case. Now, apparently there's another special prosecutor who's more qualified, getting paid less money. Again, we need to know everything. There can be no secrets here. And I hope that the judges in this case, particularly the trial judge and other judges who were involved, do the right thing. And the right thing is sunlight is the best disinfectant. Let it all be made public. Again, you're the district attorney. You're prosecuting the most important case in your life. You're prosecuting one of the most important cases in the history of Georgia, certainly Fulton County. And you're prosecuting one of the most important cases in American history. A fair trial requires a fair prosecution, and it involves full disclosure of why decisions may have been made and what the timing of things is. Can he show prejudice? Can Trump show prejudice? I don't know. Don't know enough about the facts. We know that a handful of the defendants have already pleaded guilty, and they may very well seek to undo those guilty pleas if and when more information is uncovered. I can tell you, if I were a defense attorney in this case, I would be a Rottweiler. I would not be letting go. I would be demanding everything at every moment and not allowing the case to go forward without full and complete disclosure. And remember, too, that issues of recusal and disqualification are often subject to mandamus. That is, they can be essentially appealed to a court of appeals before the trial. For example, if a trial judge rules that although there was a romantic relationship and payments of money, there is no reason to recuse or disqualify either the elected DA or the paid special prosecutor, that generally, again, I'm not an expert on the law of Georgia, but I am an expert on laws generally. And in general, that kind of a ruling can be immediately appealed before the trial because you're entitled to an unbiased prosecution and an unbiased prosecutor at the trial. And you don't have to wait for there to be a conviction in order to appeal. Some states, some jurisdictions might say, no, you do have to wait. But let's see what the law is in Georgia, particularly in a case like this. And this is a fairly unprecedented case. Now, there's another case in Georgia where the same prosecutor has been recused because of, I think, attending a fundraiser or something, some political shenanigan. This is much more serious than that. $650,000, a lot of money for a local lawyer in Fulton County. I think the public is entitled to see his bills and his time charts, and we know how much his hourly fee is, more than the other more qualified prosecutor, but we don't know how that hourly fee resulted in payments of $650,000. I mean, you do the arithmetic, you see how many hours are involved. There may be other people involved in addition to him, associates, paralegals. Again, no secrets when you're prosecuting the former president of the United States, when you're prosecuting the leading candidate to try to unseat the current president of the United States, when you're prosecuting the man who may well be the future president of the United States, especially when you're prosecuting him in a state court where he couldn't pardon himself or get himself pardoned or drop the prosecution. And when everything may turn on prosecutorial discretion involving timing and what evidence is admissible and what charges are made, whether it could be amended to charge insurrection, which would give some more credibility to 14th Amendment attempts to try to take him off the ballot of certain states. These are all critical prosecutorial decisions, and we have the right to get to the bottom of this. We have the right to know. This is not just prurient curiosity. This is the rule of law. This is the rule of integrity and decency and democracy.